question really was it speculation to say that he got it while he was in Brazil? I mean, that was, and he had two experts to say no. We think based upon everything here, we can infer the fact that he was exposed to this disease in Brazil. And the respondent had two experts that said no. You know, that's all speculation. The math doesn't add up. And the commission weighed both experts and agreed with the claimant's expert. So, I mean, it just came down to, you know, weight of the evidence before the commission.
That's Mark.
I recall the surgical nurse case. I think that was your office's case. How's this?
Thanks, Mark.
Oh, I just recall it. Maybe it was Chuck's.
Well,
Can somebody tell me?
is Chuck here? Chuck, come on.
I
Little help.
All I know is that it seems to me that the surgical nurse, we know for sure that the surgical nurse is exposed to AIDS and hepatitis C, etc. Even though this is this is an unusual disease, and we're inferring that he was perhaps exposed to it in Brazil, but there is no direct evidence. I understand the quote in the third sentence here, but the surgical nurse lost, and maybe I don't have a rational mind, but to me, rationally, she got her hepatitis C from being a surgical nurse.
So the case, yeah, so Chuck is here, and the case that you're referring to is actually cited after that first sentence, Mark. It's called Spurling. So yeah, that's the Spurling case, and Chuck says that you only have to say two words to explain that unfavorable decision, and those words are Jim Sansone, right, Chuck? Is that the
Correct.
Is everybody?
There's about 8 people here who know what I'm talking about.
Not maybe more than 8. So
1, 2, 3, 4, 5, 6, 7,
Fundamentally,
8.
it's statistical evidence.
So-
In the case of the nurse, in the case
maybe the way to reconcile these cases is that as they go up, of course, they all go up as manifest weight cases, right? So Spurling ultimately is a manifest weight case, just like Amron is, okay? So it's a manifest weight issue. Now, we argue that the wrong standard of proof was used in Spurling, but the Supreme Court didn't necessarily agree with that argument. So, in fact, didn't agree at all with that.
Yeah, no, they didn't. It just seems to me that I didn't think upon that as necessarily as a manifest weight case. How we read Spurling, but it seemed to me that the court there basically told us you can't use statistics to prove.
No, clearly, Mark, we read Spurling, because clearly in the Supreme Court, Spurling is a manifest weight case. In the Supreme Court, clearly it's a manifest weight case.
Okay, the commission, Mr. Sansone and the commission placed weight in Spurling on the fact that each time that she had a needle prick as a surgical nurse, she didn't stop to file an accident. So it was a manifest weight case. Sansone denied the case. The commission, as I recall, in a split decision, it was back when we just had all 5 in those days. In a split decision, affirmed Sansone. Circuit court confirmed. The appellate court reversed. And I want to say a 4-1 decision, might have been 3-2. The decision was written by Calvo. Subsequently, by the time we got to the Supreme Court, Calvo was on the Supreme Court. So he obviously took no part of the decision. And it was written by Justice Ryan from DeSalle, Peru. Basically, it was not against the manifest weight.
And the Spurling case, just so you all understand, it's a very common thing, a nurse with a needle prick, right? She ends up with hepatitis C, right? But she can't identify which particular needle prick, might have given her the hepatitis C. She excludes all the other risk factors for that, disease. Has experts testify that nurses are at increased risk of hepatitis C when they get pinpricks at hospitals, but it apparently wasn't enough for arbitrators and so.
At the lower level, the commission was talking about we didn't have the direct proof. And their factual thing was that the direct proof would have been if she'd been reporting these needles. In other words, they were disputing that she would have needle sticks that were unreported.
So this is a clarification that you don't need that direct proof, right? You can prove it statistically or through, through probabilities, I suppose is a better way to put it.
Because we don't know who gave Holly the position. Same thing with the nurse, we don't know.
I think this was what's the right word? You could, a respite, right? I mean, I think this was something you could actually like inhale. You didn't have to like come into contact with someone, right? I think this, if I'm not mistaken, if I'm remembering the facts
Right,
right.
and I think there might, although they don't talk about it here, there might, a bit of distinction maybe, he was clearly a traveling employee, right? So you're looking at reasonable, foreseeable, as opposed to our, normal standard for a discrete injury. So that's usually, is it reasonable, foreseeable that you're gonna come into contact with this type of disease when you're traveling? Yes.
I was kind of surprised that they didn't bring it.
So, moving on, unless there are any other questions about this, okay, good. So moving on to, Levy Company, case. So this is a case where the petitioner filed, 3 different cases, for separate and discrete accidents against, the Levy Company. One of the cases, seems to have been filed against Walsh Construction, but it's my understanding that actually that case was part of their, wraparound policy, so actually the petitioner was working for the Levy Company, even though Walsh was the respondent in that case. So the petitioner actually tries one of his cases on a 19B, and it's found that his condition is related to the injury, and he's awarded a prospective surgery based on that 19B. After that 19B is tried, the petitioner settles the first 2 cases. Those cases had previously been consolidated before the arbitrator to that last case. In order to settle those first 2 cases and leave the 3rd case pending, it's my understanding that the petitioner made a motion to sever the cases before the arbitrator. The arbitrator denied the motion to sever the cases. The petitioner presented the 2 settlement contracts on the first 2 cases to the arbitrator. The arbitrator rejected the approval of the 2 settlement contracts because the arbitrator said, I haven't severed the cases. They've all got to be done at once. You can't do them piecemeal like this. The arbitrator rejected the settlement. Under the rules, the rejection of those settlement contracts was then brought to a commissioner. The commissioner approved the 2 settlement contracts on the first 2 cases and left the 3rd case pending. So that's the kind of factual summary of the case. The circuit court, when the respondent reviewed the, approval of the settlement contracts to the circuit court entered an order which confirmed the commission's jurisdiction to settle to approve the settlement of the first 2 cases without doing anything with that 3rd case, leaving it pending. It denied the employer's motion to set aside those 2 settlement contracts. It noted that the 3rd case, the last case, was still pending before the commission, and once again, it remanded the case to the commission for further proceedings, on that last case, and then the employer filed the appeal. So when it gets to the appellate court, the employer argues that the commission was without jurisdiction to approve the settlement of those first 2 cases because the arbitrator had previously denied the employee's, the petitioner's motion to sever the cases, and the appellate court said that argument was without merit. So it said no, the commission has the discretion to approve some cases and leave some other cases pending. The employer also argued that the commission erred without hearing testimony or gathering evidence about why those first two cases were settled and the other case was left pending. And once again, the appellate court said that there's no legal support for that argument. So that Levy case is a case that may be in contradiction to a couple of other cases that we talked about maybe 2 or 3 years ago. There's a case called City of Chicago and a case called Baumgartner, right? And remember what these cases stand for? It stands for this idea that, if there are multiple pending cases, what you're looking at is the petitioner's, final condition to determine what that award should be. So the cases kind of all get blended together, and you can't really do this thing where you resolve one case and then, come back and resolve another case separately. So this case seems to have a different kind of holding than we saw in those cases, City of Chicago and Baumgartner. Everybody remembers those cases? Okay, good. All right. Elizabeth?
Yeah, I have a little bit different. This case, I took it over right before the oral argument, and really what the justices were concerned about was the fact that it was the same respondent. It was in all 3 instances was the same respondent. So how do you, being respondent number 3, make an argument different than that of respondent number 1 when you are all the same respondent? I mean, they appreciated the fact it was different insurance periods, but they were troubled by the fact it was the exact same employer in all 3 circumstances. Also, the first 2 injuries involved the shoulder. They're distinct and separate injuries relative to the shoulder, and the 3rd injury was a low back claim. So they were different parts of the person. I think there's the most recent case that just came down talking about how you can't make the argument because it's shoulder and back, but they're all the same because it's man as a whole. Really, I think Baumgartner and City of Chicago talk about if you've injured your knee in all 3 of these cases, then we have to look at it together because we're looking at the same body part. That doesn't necessarily apply when you're just talking about person as a whole, and you're talking about back, neck, shoulder. So, but in this case, it was really specific to the fact it was all the same employer. So I'm not sure it would be the same holding if you had 2 separate employers. Their concern was really because it was one employer.
The same carrier on accidents 1 and 2, or different carrier on 3?
They were all different carriers. All 3 of them were different carriers.
All right, any questions about this one? Lead company? Okay, good. Bob Red Remodeling is the name of the case. I'm sorry, so it should say Bob Red Remodeling on the slides instead of Bob Red Remodeling. Matt Belcher had the petitioner in this case. I'm going to ask Matt to come up and present the petitioner's side of the equation.
We're running kind of late on time, so I'm going to go as fast as possible. First, I want to say thanks to Dave. I don't think we appreciate enough how much his efforts here help us in practice, so thanks very much, Dave. So by way of background information, Mr. Lamonti comes here from Poland. He came in 2003, doesn't speak English. He's got a vocational background of doing automotive repair and working as a shopkeeper. In 2007, he finds himself doing construction work. July 28, 2007, he's 55 years old, he doesn't speak English, he's on top of the roof. OSHA requires, as we all know, fall protection for different industries. For general industry, it has to be at 4 feet. Fall protection is 5 feet in shipyard, 6 feet in construction, and 8 feet in longshoring. So, who wants to guess that the employer was in compliance with OSHA regulations in this case? The answer is no. So, OSHA regulations 1926.501 B1, each employee on a walking service with an unprotected side or edge, which is 6 feet or more above a lower level, shall be protected from falling by use of a guardrail system, safety net, or personal fall arrested. Mr. Lamonti did 11 feet, no fall protection, no tow board, no harness, no safety line, no net, no guardrail, no personal fall arrest system. So head first off to the roof. There's a dispute, lack of consensus among the coworkers as to whether or not the single came loose, whether somebody bumped him or whether he just went off head first. Regardless, Mrs. Lamont gets a telephone call. By the time she gets there, the only thing she finds is his hat and a big pool of blood. The ambulance took him to Masonic. At Masonic, he's examined by Dr. Kranzler. Dr. Kranzler keeps him under observation, and a week later decides to do surgery. One of the arguments in the case is that Mr. Lamont, there in intensive care, laying there under observation, since he was there for a week, he chose Dr. Kranzler, and that was his first position. As we'll see, the arbitrator commission is all perfect agreed. So one interesting note is that Mr. Lamont was continued to be seen by Dr. Kranzler for 4 months. The appellate court says that from now on, any ordinary treatment and normal follow-up subsequent to surgery or customary emergency services, that's not a choice of physician. So he went there for 4 months. It wasn't just a week. So he practiced it. The client goes to see a surgeon, sees an emergency room physician. Any follow-up that's ordinary, considered to be normal follow-up, it's not a choice of physician. Regardless, after the craniotomy, he wound up having physical therapy, speech therapy, as well as some follow-up treatment. The case goes on for a few years, continues to be paid benefits. There's a Section 12 examination of Dr. Zolman. Dr. Zolman is the director of brain injuries at the Chicago Rehabilitation Institute, so clearly she's a genius and she can do everything she says. She has a plan of treatment for Mr. Lamont. Mr. Lamont does not comply. Mr. Lamont is getting treatment from his primary care physician. He's an intern. The intern thinks that he's doing a good job for Mr. Lamont. Dr. Zolman, the director of the traumatic brain injuries at the Rehabilitation Institute of Chicago, says no. He disagrees. The respondent filed a motion to terminate benefits for injurious practice. We take the deposition of Dr. Zolman. I asked Dr. Zolman if she's aware that, you walk into the RFC, I don't know if you've been to the traumatic brain injuries, and if you walk in, there's a big sign. Our mission statement is to help people with traumatic brain injuries. They call them the victims of traumatic brain injuries. So about halfway down, I asked her, you're aware that your testimony is being used today in exchange for $10,000 to cut off benefits or deny benefits to a person with traumatic brain injury? I'm not answering that question. I said, no, you have to answer that question. Please answer. I'm going to call my lawyer. So we sat there for a half hour later, the lawyer came. So then I asked her again, and she wouldn't answer the question. So we moved on, and then I asked her another question, saying, well, you don't speak Polish. You have no idea what this gentleman is saying. You're relying on translators. They refused to answer the question. They got up, they walked out. All right, whatever. So they filed a petition to terminate benefits. They also filed a 137 motion for sanctions and a 206E, Supreme Court Rule 206E motion to assess the cost of the deposition because I was aggressive. The arbitrator, spoiler alert, the arbitrator said that while I was aggressive, the doctor was evasive. So the 206E motion was denied and 137 sanctions was denied. We take the deposition of the internist. The internist says, well, I have occupational experience and I've concluded that the person has lost access to any meaningful employment. Therefore, he's permanently disabled. During the deposition of the treating physician, of the Section 12 examiner, another reason to take the deposition called Section 12 examiner, I asked her, well, when it says here that Mr. Lemansky can go back to work, what does that mean? What kind of job? She says, well, we work with these vocational providers, and they have supported work environments. What's the supported work environment? Needless to say, we never really fully got into that. I did ask her if you're aware of any vocational market in Chicago, and they didn't want to answer that. And I asked if she had any vocational training, and she said no. So we had to have a trial. So we had it. So we had the trial, and the first witness called is a staff member from my office, so she can lay the foundation for a day in a life video. Okay? So we do a day in a life video to show how Mr. Lemansky is, now he's 57 or 58 years old, and how his life is different than when he was 55 and working on the roof. Second witness was Lisa Helmuth from Joe Belmonte's office. She came to testify about the vocational assessment of Mr. Belmonte. Ms. Copley made a 48-hour rule violation objection, saying that I failed to comply with GEAR by not providing her with the vote rehab report prior to the trial. That was the rule because Lisa Helmuth on MD, 48-hour rule only applies to medical doctors. Ms. Helmuth testified that, in fact, he's an odd lot because of his age, training, disability, lack of cognitive skills, that he's lost access to an identifiable occupation in the state labor market. Subsequently, the arbitrator concluded that it was an adjudicated perm total on either theory. So first, he was medical perm total because he found that the internist was more credible than the director of the Rehabilitation Institute of Chicago's brain clinic, because the doctor at the brain center doesn't speak the language of workers' comp. When we asked her, why do you think that he's not permanently total, she said, well, a person is permanently total, but they need to have a feeding tube, they're basically in a vegetative state. So when you ask an interrogatory practice, if you ask an interrogatory doctor, you might want to ask them the basis for their opinion, so you don't wind up at deposition finding out that when she said he could go back to work, she meant in a sheltered work environment. And then when she said that he wasn't permanently totally disabled, she meant he wasn't in a vegetative state. Regardless, the arbitrator concludes that the internist is more credible. He awards TTD through a date certain, and then awards term total benefits. He denies the 137 motion for sanctions and the 206E motion for assessment of costs, and then the case goes to the commission. We received that decision in March of 2011. As soon as we received the decision, it was basically denied their motion to terminate benefits for injurious practice, granted my request of hearing, saying that in fact he is permanently employed disabled. Of course, they stopped paying them. So for 191 weeks, Mr. Lamazzi, a person that they alleged had such a serious brain injury that they needed to care and treatment of RIC, wasn't paid any benefits. So we go to the commission. The commission affirms on all issues except strikes reference to an FCE. The arbitrator made reference to an FCE that was not part of the record. That FCE had returned Mr. Lamont to a below sedentary level. So we go to the appellate court. The appellate court basically, you can read it yourself, basically affirms the arbitrator's commission. So here's a few practice tips of an internist who is more familiar with workers' compensation can be more credible than a highly decorated clinical director who is less familiar with workers' compensation. If a respondent is finding an injurious practice, it is the respondent's burden to prove that the disputed treatment, and this is important, from Mount Olive Poll, it says, offers a reasonable prospect of restoration or relief from the incapacity from which the workman is suffering. So here's what the appellate court says. Listen, you can't just say that you think that this course of treatment is better. You need to prove that in fact you can cure him of some incapacity in order to deny somebody benefits under injurious practice. So also, what we all know to be the ALAT standard, that once a claimant establishes that he's permanently and fully disabled by showing a diligent but unsuccessful job search, or that his age, training, experience, education, and conditions prevent him from obtaining an identifiable occupation in the state labor market, the burden of proof shifts. Sometimes it's said the burden of production. So the burden shifts to the respondent. Now the respondent must prove that there is an identifiable occupation and that a stable labor market exists. Well, they brought in no evidence of that whatsoever. They brought in no evidence that this supposedly injurious practice is preventing him from turning back in the state of gainful employment. And then finally, and perhaps most importantly, the reason why the case probably got published is that now that when a claimant continues to follow up with his doctor, in this instance, 4 months after the surgery, the court held that this treatment is the type which ordinarily follows from a surgical procedure, or the sort which typically follows from emergency services, then a medical provider is not converted into a choice of disease.
Can I respond? I was the respondent. So we brought a motion for failure to cooperate with medical care, which is not injurious practices. There are actually two separate standards under Section 19B. One is you're proactively doing something to hurt yourself, and the second one is that you're not cooperating. The court basically looked at it and said, based on manifest weight of the evidence, we're putting more, we let the commission weigh the evidence. It was okay for them to believe Dr. Flores or Dr. Zulman. Our position always was that Dr. Zulman was more qualified, therefore more credible, therefore he was not cooperating with the appropriate medical care, not just some medical care from an intern. So they're two separate different causes. It's failure to cooperate and then there's injurious practice, which is separate. The court made that clear. Those are two separate issues. Also, the appellate court was clear on saying that, they just felt that manifest weight, they couldn't overturn this. doctor, whether or not he was qualified as Dr. Zolman, that was a no. And relative to the medical benefit portions of it, the court did talk about if it's just regular follow-up care after emergency visit, they felt it was reasonable. I will tell you, they cited, I think they cited a case from DC. If it goes back up, they didn't, all the other cases in and around Illinois, Wisconsin, Michigan, I think Iowa, they all say no, that counts as a choice. So I'm not sure that will always be the way it is. I just couldn't do a petition for rehearing.
All right, just a little bit, on page 19, it says, "The respondent has failed to prove that the testing/treatment that Dr. Zolman has prescribed offers a reasonable prospect of restoration or relief from the incapacity which Mr. Lamonti is suffering. Furthermore, respondent has failed to prove that Mr. Lamonti is doing things to retard his recovery." So if you want to bring a motion under 19E, under either standard, it's your burden of proof to demonstrate that, in fact, you would restore him to a state of, restoring to a state of capacity from that as an incapacity. No, the RIT was just section 12, the section 12 examination, and then criticism of other doctors who don't work with others.
So something that troubles me about the case is that in the opinion, is that after the respondent's motion to suspend benefits was denied, the respondent suspended benefits. So why did you bring the motion to suspend benefits? Did it end?
Well, no, because at the time of trial, I was doing a motion to suspend